I am very honored, the PhD students and my colleague, to welcome here Professor Eleonor Kristoffersson from Örebro University, who is a great specialist on tax law. And today we are going to have the lecture about the comparative method, which is really important to lawyers. And this is the topic that we have been discussing with our PhD students over and over again. That what to compare, why to compare, how to compare. And so we are very excited about the lecture. And
thank you. Yes, so I'm Eleonor Kristoffersson, then from Örebro University. And the aspect on comparative legal method that I'm going to look closer at today is in EU-harmonized fields of law, because I've done quite a lot of research on value-added tax, which is harmonized to a great extent within the EU. But there is actually very little written about how to analyze similarities, how to analyze differences, how to pick out the jurisdictions to compare, and so. So I've been doing a little bit of research in this field, and for the materials that I recommended today on the webpage, there is one article that I wrote about that 2 years ago. And really, I think we should start with a little introduction round as well, so that I know who you are and which fields you're in, and if you're doing any comparative research in your PhDs, or if you're doing any comparative research beside. Anyway, so please.
My name is Ilya. I'm a second-year PhD student. My field of research is law, and actually I'm trying to use a comparative legal method. I'm comparing EU legal system and the Russian legal system. Currently, I'm comparing personal data protection regulation of this jurisdiction. So, that's it.
Yeah. So you're looking at the GDPR, or?
Yeah. GDPR.
And compare it with the Russian.
And with Russian, yes, set of legal acts.
Good. Yeah.
My name is Mari-Liis Viirisalu. I'm a fourth-year student, and I do research in social security, or social services, basically. And this is a field that is, unlike many other fields, that is not harmonized much. There are some soft law standards, which is basically it. So social services in general interest is my field, and the privatization and marketization of the services. And I've done some comparative research. At first, it was planned as a true comparative work, but now the comparison is more in the background, doesn't show so much. And I compare Estonian law lot with German law, because the social security is a special, special administrative law, basically, which is based on German law a lot. So my problem basically is that it's really easy to sink into German doctrine when there is not enough Estonian books in Estonia or the doctrine in Estonian. So I'm more trying to restrict myself from comparing or bringing it in too much.
Yeah, that's the thing with German law, isn't it?
They write so much.
Good.
Hi, my name is Susanne Glien, and my field of research in my PhD, I'm a second-year student, is family law, more specifically matrimonial property regimes and joint ownership. So the matrimonial property regime of joint ownership, and also the fields where joint ownership is used. For example, in between the heirs, co-heirs, for example. And I have always done my research with the comparative method, or I have had many countries, their legal systems that I look into. And of course, the main one is Germany, because many norms are taken from there.
Yeah. Thanks. Yeah.
Yeah, hello, my name is Valueadded. I've done my have completed my doctoral thesis already. I teach law publications, and the area where I used comparative method in my thesis is unjustified enrichment.
All right. Yeah. Good. Yeah. Did you look at Sweden?
Unfortunately not.
Because we have quite a discussion in Sweden if we have this, if this principle exists at all in Swedish law, because it's not codified and it has been subject to discussion for a very, very long time. That there's no need for such principle in Sweden. But then it comes from the draft common frame of reference and so on. So yeah,
It comes down to language barriers quite much.
yeah,
In my case, Sweden is also interesting
yeah.
with the market-based social services, but it's the main legal acts may be translated, but not more.
No, that's true. Yeah. Well, the outline for this my lecture is that I will start with a little general background, and then I will discuss comparative method and make some some basic issues. And then I will discuss how to analyze similarities and differences, especially if you have harmonized legislation then, and then draw some conclusion. And as I said, my starting point is the value-added tax, and which is also called goods and services tax in other countries like in Australia and so outside the EU. But this is not going to be an exercise in tax law, I will assure you that. Well, the reason that I started to look at the harmonization or the methodology, the comparative methodology in harmonized fields of law was that I got a research project which should have been finished by now, but it's not completely. I'm a little bit late. But it was supposed to be 2015 till 2017. I have prolonged it a little bit, so it shall be finished by the end of this year. And it was funded by the Swedish Research Council. And it was a special funding form for comparative research. So there are 8 projects that are financed from the Swedish Research Council on comparative research, but my project is the only project in law, and then the other ones are in other fields of humanities and social sciences, like in archaeology and so on, Swedish language. And so that was the reason that I got this research project, and the purpose for the project then is to analyze the right of deduction of input value-added tax in Austria, Germany and Sweden. And the purpose then includes developing a methodological framework for how to carry out comparative studies in an EU-harmonized fields of law, such as value-added tax law. And the reason that I was invited here to talk about this is that I and Irene Kuhl, we both teach at a summer school in comparative private law in Salzburg. And we do that each year. And a couple of years ago, at the same time when I wrote the article that it's included for the materials today, I held a seminar for the professors in the summer school where we discussed a similar one as this one. And then she said, well, can't you hold that lecture or a similar lecture for the PhD students here? So that is the reason that I'm holding this lecture now. And in my article, which I have in the readings for today, I asked some questions related to the comparative research method. regarding the national law in the field of value-added tax, and it was that how should you decide which jurisdictions to compare? Which are the differences and similarities that you could expect to find, and what reasons can they have? And which are the typical problems that may arise in this research? So I asked myself quite general questions. And if we start with the value-added tax, it's not regulated through an EU regulation as your GDPR is, but it's mainly harmonized by a directive. And as you know, the regulations shall have general application and are binding in its entirety and directly applicable in all member states, whereas the directives shall be binding as to the result to be achieved upon each member state to which it is addressed, but shall leave to the national authorities the choice of forms and methods. And since the value-added tax is harmonized through directives, you already lose some of the harmonization here when the directive is transformed into national law. Because if you compare, for example, the German and the Swedish value-added tax laws, you will find quite a lot of differences. But they are still supposed to achieve the same result. So first, the directive form makes differences as such, I would say, and especially if you would say, where I have done most research myself is on Swedish, German, and Austrian value-added tax, and what you can see if you look at the implementation from the beginning, it seems to be an idea that let's keep as many provisions as we can from our old law, and then we adjust it to EU law. And that was how it was done in Sweden and in Austria and in Germany anyway, that they kept a lot of provisions from their previous national laws, even though they make new laws, of course, to adapt the value-added tax to the EU. And then we have the preliminary rulings as well from the European Union Court of Justice. And there we have a shortcoming, I would say, if you want to achieve a truly harmonized system. And I would say that the value-added tax, at least, is not, it's harmonized to such a great extent so that it's more a unification of law, I would say, than a harmonization of law. So it's very, very much harmonized. It's not a minimum directive, it's a really harmonizing directive. So it's covering very much. And then where questions of interpretation occur, then the national courts can go to the European Union Court of Justice to ask for a preliminary ruling. But as you already know, those preliminary rulings, they are on interpretation of the directives and on the primary EU law. It's not on the application. So the application is also up to the national court that has asked for a preliminary ruling. So the preliminary rulings, even though they are quite detailed, they are still to some extent abstract, because the case is not, or the ruling is not applied and connected to the particular case. And I think this is very important to bring with you when you read preliminary rulings as well, because it's easy to believe when you read and to overinterpret the preliminary rulings, because the European Union Court of Justice often describes the case before the national court very much in detail, but it's important to remember that, the European Union Court of Justice has not told us how to apply this rule on the specific case. But the information that we can get about the contents of EU law, that stops by the interpretation, and which leaves a lot of questions open, in my view. So in application, there can still be differences. If we move on then to the comparative method and to some basic issues, we have to, there is one statement here that you often see in textbooks of comparative law and so, and that is that researchers in comparative law study foreign legal systems. They do not investigate them. But I think that if you want to compare, like German and Swedish value-added tax law, or Estonian and Finnish law in another harmonized field and so, and you want to, because you want to go down, not stay on the abstract level, but really look at, well, how does it look in the different member states, what's happening in the different member states. Then it's a question if you can stay by studying foreign legal systems, because if you go down to the legal sources, then it's a very, very fine line, I would say, until you start to investigate it and draw your own conclusions. It depends on how big the issue is that you're looking at. If you're comparing like systems, or if you're comparing, for example, a certain kind of service, how that is supposed to be taxed, and you will look at that from in two different countries, and you would probably have to go through all the sources that there are in both countries and draw the conclusions on, well, how shall the law be applied to this kind of transaction. So I'm not, I think that you don't study the foreign legal systems, and you don't investigate them, that it might not be so relevant for when you're making a comparative study in a harmonized field of law, in my view. And then we have the functional approach. You know, if in the textbook, for example, as Weigert and Kurtz always write that you should focus on problems and not on rules, because if you focus on rules, then you can get very lost if you just see that, well, we have this rule in Estonia and we have this rule in France, but maybe it's regulated, well, part of the thing that you're examining is maybe regulated somewhere else as well. So that is dangerous in general, to pick some rules and compare them, because it doesn't give you the whole picture. So it's for sure a good idea to look at problems. Well, how does this legal system deal with distance sales of goods or whatever you're looking at? But I think that if you're analyzing EU-harmonized law, then you can actually, or you can see that at least that it works in many cases, that you can actually look at, well, for example, the exemption from value-added tax on insurance services. How is that implemented in Estonia and in Denmark, for example? So then you can actually focus on roles in the directive and look how they are implemented. So I think that the functional approach, it's important to bear in mind, but you see many theses and other pieces of research which actually look at a set of rules in the directive and how they are implemented in another member state. To analyze both similarities and differences, and I think I sent you the material as well, the article where they discussed about shall you analyze the differences or shall you analyze the similarities? And I think that it's obvious that you shouldn't only analyze the one thing or the other, but also both similarities and differences are interesting. And in a harmonized system, it's easy, of course, to focus on the differences and assume that also similarities depend on harmonization. But it's not always the case. So I think it can be quite a pitfall if you analyze harmonized law to skip the similarities and just to assume that they are due to harmonization. Because sometimes there are rules that are optional to implement, for example, and why have two different member states chosen or not chosen to implement an optional rule and so on? And or similarities can have other reasons than the harmonization. They can have historical reasons, like, and I will come back to that, but one example is if you look at the Austrian and the German value-added tax laws, they are very, very similar. And they have concepts like Unternehmer, like a business person, which you won't find in the directive, but you find it both in German and Austrian value-added tax law. And when you go a little bit deeper into that and examine the similarities, then you will find that Austria got the very old system of taxing goods and services from Germany already in 1939 due to the Second World War. And then in Austria they sort of forgot to abolish this in 1945, so they kept the same taxation rules until 1957. And then both Germany, when they eventually started with the value-added tax and the EU-harmonized value-added tax, then they kept as much as they could from their old rules, and it was the same development in Austria. So when they abolished the old German way of for taxation in 1957, they still kept the basic structure and the same concepts, and so that is the reason why you find the similarities between Austria and Germany, and not at all because of the harmonization. And then another feature which is important when you're doing a comparative study is, of course, to use the result to have a purpose with the study, and not just to compare and identify and analyze similarities and differences. But why are you doing this? A basic feature when you do a comparative study, as you said, is how to choose the countries. And I would say, and this is not completely uncontroversial either, that it depends on the aim of the study. But if you decide your choice of countries because of the aim of the study, then you are already from the beginning a little bit biased, aren't you? Because then you pick out the countries that suits your aim or your research questions. So I think that if one should be completely unbiased, one should just pick a lot of countries and make a comparative comparison. But I mean, that is not how it works, because it's not possible, and you will get so much irrelevant materials, you will never finish your study. So somehow, I mean, you decide your countries or your different jurisdictions in relation to the aim of the study. I will come back to that very soon. When you deal with harmonized law, then you have to decide whether you want to compare systems or implementation. And what you do, I think, is you compare the EU system with the Russian system. And I think when you have a regulation, it's no problem, because the regulation, it's both EU law and at the same time national law, since it's not transposed into international law, but it's valid as it is. But if you have a directive and you compare like the EU value-added tax system with national law outside the EU, then you will have a little bit of a problem, because then you will make your comparison on different levels. If you, for example, would compare the EU value-added tax system with the Australian or the Canadian system, then you would have the case law in the Canadian or Australian system that goes down to application and how it is in national law. But if you compare it with the EU system, then you will sit there with a directive, with the preliminary rulings, and you won't have the application level, and you won't have the implementation level either. I would say that this works if you have a more general, if you have like a broader question, or if you have I held a lecture just a couple of weeks ago together with an associate professor who made exactly such a study that I just talked about. She compared EU value-added tax law with Canadian and New Zealand law, I think it was, on e-commerce. But it was quite a long time ago. It was like 10 years ago. And at that time, we didn't have anything on that in Swedish law. So we didn't have any case law. There was really no opinion on how those kind of transactions should be dealt with. There was no Swedish opinion on that. But you could see some materials from the EU and so. So she said that, well, it worked for me since there was nothing to find in Swedish law anyway. So, well, yeah. It works, but I think that one has to be aware of when you're comparing harmonized law that it might be better to choose one or two jurisdictions within the EU in order to get down to the same level, so that you don't like compare apples and pears a little bit. How many countries is also an interesting question for a comparative study. And I would say that it depends on what you're doing. If you want to do a broad and general study, or if you want to do a narrow and deep study. It also depends on the size of the study. And also the number of questions examined. I have a colleague in Uppsala, a Swedish professor of law, Bertil Wiman, and he, I remember when I was listening to him when I was writing my own PhD, he said that, well, it's always good to make like a diagram where you take the questions, the jurisdictions, and then you try to see, well, how many pages would I deal with each issue here? And I listened to him again, also just a couple of weeks ago, when he was discussing this formula, so to speak, on how to decide how many jurisdictions it was possible to include in the study. And then he got down to his own experiences when he was supposed to write his second book, because in In Sweden, when you want to become a professor, then you normally write your doctoral thesis and you write at least a second monograph. And you do a lot of other things as well, but that is sort of a minimum standard. But he never finished his second book. And the reason for that, and that was what he talked about a couple of weeks ago, the reason for that was that he had so many questions. And when it was not so many questions if you looked at them broadly, but those questions, if you broke them down in all the alternatives that there could be for each questions. He was writing about taxation, taxing groups of companies and groups of company taxation regimes, and wanted to look at different aspects of this. And when he broke them down to smaller pieces, maybe he had like 30 issues or something to examine. And he should then look at, I think it was 6 jurisdictions or something, and look at all those aspects in all the 6 jurisdictions, which made him never end. And I have similar experience with my current research project on deduction on input value-added tax, which also includes a lot of issues, a lot of different issues. Because I thought that, well, I take the EU law, I go through all the cases there, maybe it's 200, 300 cases, and then I look how it is in Sweden, and then I look how it is in Austria, and then I look how it is in Germany. And I must say that I have come to the conclusion that, well, that idea, that is not really possible to carry out. I mean, you can look at different aspects, but it's too much, because it would probably result in, I don't know, 2,000 pages at least, if I should make a full comparative study on all that. So that is, I think it's sort of a good thing to keep in mind, really, when you're identifying how many jurisdictions you should have, just really to see, well, how my broader issues there that I have, how many different little aspects and angles do they really include, and shall I then add all those jurisdictions? Well, maybe it's enough to have 1 or 2, I would say. Yeah. And I can share another experience as well from when I wrote my second book about the binding force of tax judgment, you know, how far they reach. And so, for what, how far they are binding. And I tried to make a comparative study with Norway and Denmark, which was not a very big study then, but the problem was that nobody had really done any research in that field in Norway and in Denmark. So that would be, for me to find out how it really was in Norway and Denmark, I would have to do the research myself. Maybe that brings us back to the first issue. If you're supposed to investigate the other country's law or not, but that became too difficult as well to make a full comparison. So I think I sort of landed in the way. Was it you who said that you wanted to make a full comparative study, but it ended up in a little, small one. So I sort of just picked the interested features that I found in Norway and Denmark, and reflected about them in my analysis and so, and got some inspiration. But to make a full comparison, that was also impossible due to the fact then that no research was done in Denmark and Norway. Well, then when you come to which countries to choose and to see what is comparative, then you often see in the textbook that, well, that it's discussed from the legal family perspective. And I think the legal families, the idea about that, and I think it becomes more and more old-fashioned also in like in private law. But the idea is that, well, if you use a parent legal system, then you don't have to, that is a way to simplify your study. If you look at, for example, the French system and the German system, and you assume that, well, the Italian and Spanish system, they are, well, sort of similar to the French one, and the Austrian and yeah, maybe even Estonian system, that they should be similar to the German system. So it's enough to look at the German system. Of course, you miss out a lot, but it's a way to sort of simplify your study. What I have found when I look at this from in administrative law, and I think that goes for administrative law in general, that you don't see the same similarities in the legal families as you might do in private law. I think it's not a very useful tool to pick out the jurisdictions to compare when you compare administrative law and when you compare harmonized fields of law. And I have an example here from my value-added tax. I think it depends. You can be much freer. It doesn't have to be wrong at all to compare, for example, Estonian and Danish value-added tax law, and that could be an exactly as valuable study as if you compared French and German value-added tax law. And I have made some examples here then that the first one is that does a study aim at giving information to new member states on how the Value-Added Tax Directive and the case law of the Court of Justice of the European Union is understood by the member states that have been members of the EU for a longer time. That was when I wrote my doctoral thesis between 98 and 2001. Then Sweden was quite a new member in the European Union. We became members in 1995. And it was about, then I compared German and Swedish value-added tax. And then I used the German, Germany as for my comparison to get information about issues on application, for example, on how would this be applied in Germany, which has had this value-added tax from the beginning of the 70s. And applied this directive. So I think that could be, well, for that study it worked very well to look at Germany and then Sweden. Does the study aim at showing how the EU VAT law is implemented, applied and understood in the jurisdictions that affect most taxpayers? That could be a reason to choose big jurisdictions if you want to show a more general picture of the implementation in the EU. Maybe it's not so good then to use a very small jurisdiction like, for example, Denmark and another small country, Malta, for example, for your comparison, because that doesn't say so much about the situation in the European Union as such. Does the study aim at examining how different legal systems understand and deal with EU VAT law? Well, then you can choose, maybe you can choose the legal families if you believe that you can find like differences there, and say that, well, if you could identify then the Germanic legal system, how does that in comparison to the common law system, and so then maybe you could use the legal families idea. And does the study aim at revealing differences in the system that is supposed to be mainly one and the same? Because if you have a harmonized field of law, then I mean, the differences are always very interesting. You want to spot them and say, well, but here it's supposed to be the same, but here we have differences. And then I think you can use any jurisdiction, but a very good thing to do in such a case is to make a broad pre-study and see if you can spot at least some suspicious, if you can have some suspicious or where it differs. And my current research project, that was a little bit like that actually, not on the methodology part, but on the input value-added tax part, because I was teaching value-added tax in Austria. And when I was asked to do that the first time, I thought that, well, it's in German, that's a challenge. But how difficult can it be? Because I know, the case law from the European Union Court of Justice. I know a lot about that, and I know a lot about the directive, and so it can't be that difficult. So, but then I hold my lectures, and then it came up. You have this idea that you know how it is. And how it is supposed to be, because you know the directive, and then suddenly somebody raises that. But what about this? And then you find a lot of really, really interesting national little specialities, and I know we have them in Swedish law as well. So, and that's sparked my interest to compare Sweden and Austria, and also the methodological issues that how to deal with all those differences that you find. But my point here is that if you're after the differences, because it's supposed to be a harmonized system, then you could actually take any jurisdiction, and the more differences, the better, I would say. So if you have a really poor, suspect that you have a really poor implementation in one country, that would be an excellent country to compare with. But as you see, I'm focusing a lot here on the aim of the study, and as I said, it's not completely uncontroversial. Well, the pitfalls then when doing comparative research, I think the biggest risk is if you have understood the content of the law correctly. And to understand the sources of law and the sources of implementation and how to deal with them correctly. Because if you only have experience from one country, you will probably start dealing with the sources, because you will see the same sources. You will have the law, you will have the written law, you will have the case law. Maybe you have, at least in the Scandinavian countries, we use the preparatory works a lot. You probably look for preparatory works, for draft legislation or so. You would probably look for that and so on, and then you have the literature and the legal literature, and you will probably use them in the same way as you would use them if you were dealing with your own sources, which is often not very well. One thing that you can be sure of is that they are probably not used in exactly the same way as they are used in your own home country. And also to understand the legal culture and the context where the law is working. So my recommendation how to deal with this is that I think that even though we nowadays have all the materials, or very, very much of the materials electronically accessible, so that you, in a way, you can do comparative studies very well from at home and from your desk. I think it's still very good to plan for research stays abroad, both in the beginning of the study and when you have done your study to confirm that it's really, that you have understood it in a correct way, and also to get a feeling about the context and the legal culture. And also interact with the researchers from other countries. That is, of course, an alternative. And consult an expert to verify that you have understood it correctly, because it's so easy that you have missed something out. If we come then to the similarities and differences, and I don't really know what the time is. Is it time for a? No, it's not time for a break. No, it's only time for a break, is it? Yeah, you usually have a break after 45 minutes, no. Or you don't? No. All right, no, then it's no problem. Yeah. In Sweden, it's a sin if you don't give the students a break after 45 minutes. So we always have 45 minutes and then 50 minutes break.
Should that actually be up to you?
Yeah, yeah. But I can do the lecture part, and then we can have the discussion after a short break. Well, if we analyze the similarities in harmonized fields of law, then we will find a lot of similarities, of course, due to the harmonization. But similarities can also be explained by legal system central components. And what I mean here is, for example, if you have a value-added tax system, then you will have a set of rules about the taxable person who is liable to pay the tax, about the output value-added tax, the tax on the transactions, the input value-added tax, that is what the tax on the purchases, that you deduct them if you're a taxable person, and so on and so on. So it's not, also if you have just two value-added tax systems, if I would compare the Swedish system with the Vietnamese system, I would find my way quite well in the Vietnamese text as well, as long as far as it was in English. Similarities when implementing optional rules are interesting, as I mentioned before. Why do we choose to implement or not to implement the optional rules that we don't have to implement? What is the political background for that? And also similarities in non-harmonized fields are interesting. I gave the example before about the similarities between Austrian and German value-added tax. That depends on that it was the same during the Second World War, and after that sort of survived in the German and Austrian value-added tax codes. But if you find similarities where there is actually no harmonization, that is also interesting, of course. And if we come to the, that was similarities. If we come to the differences, well, then we will have some differences which we can expect, and that is on the optional provisions. If we have exclusions that are allowed to be made due to the directive, and also if you have EU-harmonized law, then you have often derogation due to the accession treaties. When the new member state enter into the EU, then you will have, then they often negotiate derogations in all different kinds of law. So if you don't find an explanation in the value or in the directive or whatever your EU legal act you're looking at, then it's a good idea to look in the accession treaty as well, because there are often derogations which are of course then expected. And then more unexpected differences, and that is that, well, if we have a harmonized field of law, why is it then not understood, should it be? Why is it not understood in the same way in all member states? And as I mentioned before, we lose some already in the directive form. In the implementation we will get differences, and in the preliminary rulings, as they at the interpretation level and don't go down to the application level, they will also have differences. And I have one example here. It concerns reduced tax rates. Both Sweden and Finland apply reduced tax rates on transportation of persons. But still, in Finland, we have 10% a reduced tax rate on dog sledging, because it's supposed to be a means of transportation. And in Sweden, it's 25%. I suppose it should be a means of transportation in Sweden as well, but it's not. In Sweden, it's a pleasure that you do when you go with the dogs, and it's not a transportation service. And this transportation, I'm not sure, but in Sweden we have a very strange thing there as well, which I haven't done a comparative study on, because it's a little bit, maybe a little bit strange, but you remain a person for a very, very long time in Sweden in terms of the reduced tax rate. So even if you're transported in forms of ashes, it's after death, and you're cremated and are transported in as ashes, then it's still a transportation serving regarding to transport persons, but not dog sledging. When I came to those unexpected differences, so to speak, then within the harmonized area, then I asked myself the question that why doesn't it, can it be the same in all member states? And then I started to study some comparative. It's supposed to be an O there as well, not only that. Then I started to read some comparative literature, read a bit about the legal transplants, and also about the legal formats by Sacco. And I came to the conclusion that, well, I think that one can't really, that this full harmonization, that it's probably not achievable at all, that there must be differences due to external factors such as cultural, societal, political, linguistic, not to forget, and conceptual factors. Because it doesn't help if you harmonize the words and the concepts, and so when you put them down in a context and in another legal context, then it's very, very difficult for them to come out exactly the same in all member states. And I think when you think a little bit further on this, when you have from any field of law within a jurisdiction, and where you have different courts, different district courts, for example, we're not so surprised that it's different. The same issue can be dealt with differently in different districts courts or in different courts of a lower instance, and that is the reason why we have a court of the last instance, isn't it? So that it can be clear how it is supposed to be judged, and then you're still within the same country, where you may have or may not, but most likely don't have different legal cultures, but maybe you have different legal cultures within the same court or different judges that understand the law differently. So my conclusion is there that we have those differences within the harmonized area, but it's very, very difficult to get rid of them fully. Because in a harmonized field of law, the room for those differences are limited to some extent, since the Court of Justice assists with interpreting the directives. So to some extent we have common concepts, and also that we have the infringement procedure. So when it differs too much between different member states, then the Commission can sue that member states and actually try the application as well. And did you know that the most of these infringement procedures before the European Union Court of Justice, they are initiated through that the Commission gets a tip from somebody within a member state, and they actually have this institutionalized now. So there is a web formula at the web page of the European Commission where you can report if you have some suspicion that your member state is not complying fully with EU law, and that is for most of the infringement. Yes. Oh well. How is it? I think you can be anonymous. I haven't done it myself, I must. I have a very eager doctoral student who has tried this. So, but I'm not sure. I think you can be anonymous. Mm. All right. So my conclusions here is that when you're doing a comparative study in harmonized fields of law, one can choose jurisdictions quite freely to compare. It depends on what you're looking for and what you want to do with your study. It's not necessary to choose apparent jurisdictions. There are expected differences due to lack of harmonization and unexpected differences within the harmonized field of value-added tax or in law in general. And in the field of value-added tax, and didn't touch so much upon that, but of course if you have a system that is supposed to be consistent and it's not, that can of course be used, and in the field of tax law it's used to achieve double non-taxation, so that you have a cross-border transactions which is the state of origin doesn't want to tax it because it's supposed to be supplied in the other member states, and the other member states consider it supplied in the member state of origin, and then it's not taxed at all, which is very unsatisfactory, at least for the tax authority, not for the companies, and so. So those were my conclusions on this, and I had some questions here in the program, but I just thought we could have a little bit of general discussion about the comparative legal research, and I have the first question, what are the different purposes of doing comparative legal research? Why do we do it? Who should do or is doing comparative legal research? Scholars, but any other? Who are the beneficiaries of comparative tax research? What is its usefulness? How can a comparative legal method be defined, if we can do that? How should one define the scientific requirements as regards comparative legal research? And so on, how you do it more in practice, and what are the pitfalls in comparative legal research? So, and we don't have to take them one by one. We can just, if you could want to start, for example.
Yeah, sure.
Yeah.
Well, I mean, what I think that why should we do comparative research? When I worked in Ministry of Justice, then when we had a legal problem that was not solved in Estonia before, was a new one, or maybe that we wanted to improve our system, then I haven't seen a draft of law before that wasn't like comparative research done before that. I think that's one of the things when you want to implement something better, or like when you have a new field, for example. Then I think the comparative research is really important.
Yeah. So in all draft legislation in Estonia, you see a comparative analysis?
Yeah, I really haven't seen any that hasn't have any comparative legal research done before that. I think that maybe because we're such a small country, then we always want to see how the others do it.
Yeah.
And then we had this insolvency law, bigger revision of the system. And then, of course, it's good to look at the models, all the different models. And then I think that maybe you don't take the parent countries, you don't have to take them, but when you want to see the bigger picture, then it's good to have some examples and see what are your options. And that's a good starting point to see where you could go.
Yeah.
You know, invent a bicycle, so to say, that you can see what is done before. It's also good.
Yeah. In Sweden we do it a little bit, you sometimes see comparative analysis and sometimes not in the draft legislation, so it depends a little bit on. Yeah?
Well, that also answers the second question, so it's the legislator that should do the comparative analysis.
Yeah.
And coming back to the first question, it's also a bit tricky with the another country to compare with. Well, I have had some experience with the social law and social law codification, and there are basically two questions you have to look at, distinguish. One is the legal system, and it was a codification process going on. If you take Germany, which has the codified social security, social law, it's a very good starting point to compare Estonia with the German system. On the other hand, if you look at the social policy, then Estonia has taken the Scandinavian countries and Great Britain as a role model. But as for the legal systems, they're not so, they don't have this codified system.
No.
So you basically have two really different role models.
Yeah.
One where you look at the systematic questions or the law system, and the other ones where you look at the social policy issues.
Yeah.
So that makes the comparison even more
Absolutely, yeah. Yeah, because you have the same legal system but different aims, so that is, yeah. Yeah.
Well, yeah. In my research, I used the comparative method more from the practical point of view, as I want to define the scope of legal obligation of parties and compare them each other. For instance, companies who deals with personal data and they want to operate, for instance, in EU and Russian markets. So they face the problem of different legislation, different regulation, and so it's defining legal obstacles for such operation. So I use it more for practical reasons.
Yeah. I must say that I have been doing, or I'm doing some comparative legal research sometimes when I'm asked to write in an expert assessment in tax procedures. And it was not very long time ago when there was somebody asked me to write about building services. If you build a house and you're an entrepreneur, and then you have to pay damages because you're delayed or something like that. And the issue was that, shall these damages, do they reduce the taxable amount for value-added tax? And the Swedish tax administration said, yes, it does. But then in this case, it was, what do you call that? Skyddsgericht. It was a private law case in a Skyddsgericht. It was a private. It's not a court. It's the other thing. What do you call it? No, it's not a court. It's the private dispute resolution. Arbitrage. Yes, it was arbitrage, and the party that contacted me, they wanted to have as much. They wanted to have a payment including value-added tax, and they didn't want their damages that they were possibly liable to pay to reduce the taxable amount, because then they wouldn't get any compensation for the value-added tax in the first case. So it was a little bit strange case, because in Sweden everybody is normally very happy that damages that you have to pay, that they reduce the taxable amount. So then I thought that, and I said that, it's really, really difficult to write on this in a convincing way. I don't think that I can do that. But then I took a look around. So I looked in England, and there the tax agency was of a completely opposite view, and said that no, such damages shall not reduce the taxable amount. I looked in Germany, and it shouldn't either. Then if you look at the case law of the European Union Court of Justice, it's nothing that says that damages shall reduce the taxable amount. So after my comparative analysis there, it was no problem to write in the same direction as the client wanted, and do it in a convincing way. So so I think it can be used. In a harmonized field, it's very, very useful to look around and see that, but maybe some other, it's not sources that have any authority. What the tax authority says in another member state, and so, but it can give you good arguments anyway. And say that, the general opinion in 5 other states, member states, is actually the opposite as it is in Sweden. So at least it's a not obvious question. So. Shall we move on a little bit? And maybe you who are on the run here, maybe you should go on. If we can see the beneficiaries of comparative, maybe we have touched upon that already. Maybe the pitfalls and the scientific requirements also. Question 5 and 6, maybe. If you can use, for example, can you rely on secondary sources? Must primary sources always be used, like case law? How do you do yourself when you dig into German law?
So thinking about this
5. This 5 and 6 maybe.
Sorry.
Yeah. It's very. How should one? It's difficult to answer when you don't see the question. Yeah.
How should one define the scientific requirements as regards comparative legal research? Okay.
Yeah.
My point of view is that the doctrine is definitely not enough.
No?
I've always looked at the primary sources as well. Again, depends on to how how deeply the research goes, because there are like overview books, whatever, where you shouldn't go into that depth, of course. But as for the doctoral thesis and narrow and deep questions, I don't think that that doctrine would be enough.
No. And what about the pitfalls? Because you mentioned that you have sort of one of your pitfalls in your research was that you get so much information about German law, didn't you?
Yeah, I did say that. Yes. It's such a broad topic that it's difficult to start with it or just explain it in a couple of sentences. Think about it a bit.
Yeah, but as a procedure.
In my case, I think it's the question how to balance the legal comparison with my own analysis.
Yeah.
So if, especially when there isn't any court cases, there isn't any doctrine in Estonia, so basically you tend to take over everything.
Yeah, I understand.
And this is a big question that you shouldn't, and no one shouldn't actually do it. And at the same time, I cannot present it as my own ideas only. No. So I have to bring in the legal comparison, and in the end, in the citation, it always shows that everything that you have taken over from Germany, for instance. And there are many critics in Estonia who say that Germans, that we shouldn't take over so much from Germany anyway.
Right. Yeah.
And to balance it with there's a question. How to balance it? Should I take then another couple of countries to balance it? And then there's again the problem of going too broad.
Yeah. And I can absolutely see the risk that, I mean, your thesis on Estonian law, but suddenly it's a thesis on German law instead, or mainly a thesis on,
And so in my case, I know I should look also into Scandinavian countries and then those legal systems. I know it would be relevant, but then there's the language barrier again, that you don't have access to all the necessary materials. And then in that case, just the legal, the primary source isn't just enough.
No.
Yeah, because there is so much that is like hidden behind it, you can't see in the primary source.
Absolutely, and I would say especially maybe in the Scandinavian countries where we have quite little written law.
Yeah, exactly.
Yeah, so,
So much behind it.
Yeah, do you need to leave?
I need to leave,
Yeah,
I'm so sorry.
yeah, no problem. Thank you very much for attending. Yeah, and the sources and
I agree that we use as well as primary sources and secondary sources, but what I want to stress on is that from my practical experience, it is very important to clearly identify what are we looking for by this comparison, because for instance, if we are talking about data protection law, it's a huge mass of information that's in Europe and Russia. And if, what I started to do is compare different provision, and it's too long, it's too heavy, and there is no reason to do it. And this is why I understand it and focus on particular question. For instance, I take the case, imagine case, and which involves the data transfer between, for instance, Estonia and Russia, and then analyze only this particular case in particular questions and explain more practical and more useful than just a description of different legal systems.
Yeah.
It's too big.
Yeah. So it's very much this functional approach that you use. Yeah. But how do you do then? I'm just curious when you what is your outline then, or is it that issue and that issue and that issue? Or how do you?
I defined 3 or 4 questions.
Yeah.
Like sources of law, then accepted effect of the law, applicability, and the scope of application in regard with this situation. And then I just find first of all sources. What legal act regulate this particular thing. Then analyzing applicability of this law to different situations. And then I use sort of code practice, like in Russian we call it Eleonor, and now I'm searching for practice in Europe. And like asking the same questions, like for the core practice. And basically that's all. And I form able with the answers for these particular questions.
Good. And do you have somebody to ask in Russia, or are you yourself an expert of Russian? Russian? Yeah. Yeah. And in Russian law. Yeah. Good. Very good. Yeah.
Well, then to continue with the same topic that Marianne was talking before, then when you have the choice between the primary text and the secondary ones, then I think one thing is to read the norm, and then that's of course always important, but there are so many court cases where the court practice is totally different than the law written down. It's not contra legem maybe, but it's like when you read it, you don't see the things that everyone knows in the country, that they know the court practice, and that's why I think it's always good to look at both of them.
Absolutely.
Yeah. What I wanted to ask, I don't deal myself with directives and the harmonized law, but in Estonia, for example, when the directives are taken over and are implemented, and then there has been talk that should we take the directives like words and put it in our own text, or should we try to harmonize it more? How it is in Sweden? There has been some criticism, for example, in Estonia, that when maybe we take it too literally, copy paste and really try to follow every word that's written in the directive.
Yeah, unfortunately we don't do that in Sweden. No, we keep as much as we can from our old legislation, and then it becomes quite poor harmonization, I would say, in general. And then it's discovered after a while that, this provision that we thought that we could keep, no, it doesn't really fit, so we have to change that. So we are not taking over the directives word by word. We are very much adapting what we already have to the EU instead. And I think some middle way would most likely be the best, because I think it's good to use the freedom that you have in the directive, that you actually you don't have to take it over word by word. So I mean, if you have something that suits your system better, or you have something like in Tambert Grauberg, did you attend the public defense today on his thesis? No? No. There was a public defense today, and in Estonia there is already a provision that, there is already a provision that covers this, what comes new in a directive. And then I think, you can just keep the provision, but then have to be aware that you have to understand it in a completely different way when the EU comes into play. In Sweden, I think we have this, but I think it might be changing. But when we entered the EU in 95, it was a really strong desire to keep as much as we could from the legislation that we already had, and that it doesn't result in a very good legislation.
Yeah,
so I think it's not bad. What I think it's maybe it's better to do what you're doing.
Well, I don't know. I just have seen, and I have seen it being criticized. That's what I thought. Like, is it like are all the member states doing it like that? Or, because it can result like in a weird way. Like you have your normal provisions, and then comes like something that's totally out of the box, and you don't see like where it comes from. And usually, when you don't understand the norm, then maybe it comes from a directive.
Yeah,
it can be the case.
Yeah, I bet, because it doesn't fit into your legal system somehow.
Yeah.
Good. Yeah.
But about the pitfalls, I think one thing that wasn't discussed before was that maybe you get drowned by the information. I think when you're doing comparative research, then it can't really be your objective to, as you said, investigate the system, or like just you really can't do it. I think because you don't live in the same context as that all the other people who live in this country do, and so you couldn't really like absorb all the information. Maybe you don't understand it, so maybe you get drowned in the information when you have so much of it.
Yeah.
That could also be a pitfall.
I used to have one comparative project a couple of years ago about tax secrecy. And we had 2 doctoral students in that project, and what we had the opportunity to do really in the beginning of the project was to make a big conference. So we had people from 37 jurisdictions who wrote national reports for that conference. So we got a really, and then we had the conference and where it was presented and discussed, and so we put this together in a book and wrote general report and so on. But I think our 2 doctoral students, they had such great materials for their comparisons, because they could have this nice overview of all those 37 jurisdictions and really pick out that what fitted their studies. And they both also ended their doctoral studies studies quite successfully and in time and so. And I think that because they had this really good comparative pre-study, they could focus very good and pick out the right jurisdictions. So I think that is a very good position to give you a good starting point to give your PhD students if you have that opportunity. But I think it's quite seldom that you have that, but it was really worked very well.
Yeah, in those materials you gave us, then there was this talk about the functional approach.
Yeah.
And that's one thing that when I studied in Constance, then Astrid Stadler was the one who talked about the functional approach. And I think that's also an important thing to keep in mind. For example, there was a huge problem with home loans. The crisis that started in the US, and then after that, everyone couldn't pay their mortgages and so on. And when I had to study it from the US viewpoint, where there was a saying that if you give your keys back, for example, then it's like the US has this kind of system. And you couldn't really find anything in common law, the norms or nothing written down, but it was really helpful to see how they solved the problem in the functional sense. There were policy documents, and that's where you could find the information, but not the text. Yeah. But on the other hand, when I'm writing my doctoral thesis, then I can't use the functional approach so much. I have to look for the norms that are dealing with joint property ownership, and I think that really depends on what your research is about.
Yeah.
Using functional or just...
Absolutely. Yeah. Good. But I also think that when you're, for example, if you want to use a questionnaire for a comparative study, I think it's even though you maybe you don't formulate the questions like fictive cases or so you seldom do that, but I think it's important to bear the functional approach in mind somehow, isn't it? So that you, because if you focus too much on the rules and forget, and you just formulate the questions on the rules, then you will get very, very strange answers that are really like from up in the blue. So yeah, so I agree with you.
We have one question, the methodological question. How much, for example, you ask from your students whom you supervise to make some kind of methodological list of questions, what to study from the other sources, or what kind of recommendations you give to your students? Because we discussed it, and it's really a very important question, how deep you have to go to study all the sources which were referred in one and another article. And if you go there, do you have to prepare with your students some kind of plan or something? I'm asking as I'm a supervisor, just to get some good advice what to do with these comparative methods.
Take it once more.
How much you plan beforehand your activities with foreign law, for example? Do you have some kind of questionnaire? You go through every country looking at the same, or just here it's through your everyday work, you just take your concept and you look into the different legal systems without any specific plan that I have to look into the court practice or that, and that's the theoretical literature or maybe.
Yeah, I think it depends very much on just thinking. No, I would say that, I mean, with the ones that we had in this big project, they were involved in the entire, also when we were making the questionnaires, and so even though they were maybe not contributing so much, but they were there in the discussions, and so we had quite a few meetings on the questionnaire, and that is, of course, very good, I think. But I have had doctoral students which I made, for example, comparisons with Germany, and so it has just been, well, go and do your comparative study and come back then. So, where I wasn't involved at all much, and so it depends very much on. But for the methodological part in the thesis, we expect the doctoral students to be quite transparent, and the reason for that, and really describe that, well, what material did I use, which are my shortcomings here, what couldn't I check, and so on, and how did I do, and how do I know that this is up to date, or do I know that this is up to date, and if I don't do that, what date did I stop, and so on. And I think that is important in.
Then you would say you dare to use sources where you are not able to read original text. For example, are you brave enough to compare your tax law with Vietnamese tax law?
Yeah.
Knowing that you are not able to read original.
No, of course, no.
Yeah, but you still compare, but you have to be very honest.
Yeah, then I have to say that, well, I have only read this in English, and we have had a thesis in Sweden where the doctoral student has done a comparison with the German law, for example, without reading German, and has only read secondary sources on German law. And then it's, of course, not a very deep comparison, but maybe 5 pages or something in the thesis. And you can get away with that as well, as long as you're transparent. You will get criticism for it, because you should have learned German. If you write in private law, it's very important to make a comparison with Germany, for example. And it's considered a little bit like not so nice to use English secondary sources on German law, but you get away with it as soon as you're transparent. But if you wouldn't have been transparent, then I think you would have a big problem.
But I think when we compare something or some legal systems and it's usually Germany that we choose.
Yeah.
Is Germany as important in Sweden as it is in Estonia, or I mean, is it like the main country to compare systems with?
No, I would say traditionally in some areas of law, Germany has been very, very important, like in company law and so. But nowadays, not so many younger people speak German, and it's much more common to compare with like USA, Canada is quite, England, yeah. I think Spain is upcoming. Very many young people learn Spanish in Sweden.
Does it depend on the languages that people speak, or like just the shift, the focus has been transferred somewhere else?
I think we have already, well, we have all the time had quite, or not, well, at least my lifetime, have had quite a focus on England and the US. So, and that, well, you can see that in research as well. Good. But we still have people who do comparisons with Germany and also with France and so. But it's often the practical reason for language skills, and so that depends. So I think it might be quite soon time to finish. Do you have any more questions or so many more things that you want to bring up? No? Then I must say thank you so much for coming and for listening and for participating and for staying to the end. So thank you so much and good luck with your research. And you have my email address on the pictures and so if you want to, if you have some questions about Swedish law or whatever, you're welcome to just send me an email and I will do what I can for you. So thank you.